Such a wonderful turnout for the Philip J. Shapiro Endowed International Visiting Scholars Program, which was established by a wonderful alumni of ours, Philip Shapiro, class of 1978, who is with us today. So this is Philip Shapiro. Couldn't make it as a pro basketball player in Europe, although he tried in 1970-something, but he has made it, as I will tell you, in the shipping world, and from his success in the shipping world, he has funded these scholars lectures for us, which we are really, really happy. So Phil is the President and Chief Executive Officer of Liberty Shipping Group and Liberty Maritime Court. Both are New York-based ship management company, as well as chairman of the board of Liberty Global Logistics. He likes that word, Liberty. It rings true for him, which is a multimodal marine transportation and logistics company. And basically what he does is runs one of the largest independently held U.S. flagged pure dry bulk shipping companies. So that really doesn't get to him at all. It's just doing this kind of business. But really what gets to him is he's probably the leading spokesman in America for American flagged and owned ships. He's testified so many times before Congress, often with great frustration, but nevertheless great patience, that he's the face of American shipping. But some of his stories have been unbelievably successful. Somebody can speak to him for a minute. So after, he's been very involved with issues of piracy. He led the ultimately successful battle to allow ships to have armed guards on them to fight off pirates, as a result of the failure of Tom Hanks to successfully fight off the pirates in that movie. You all know what I'm talking about. Anyway, so it's a great honor, and we really appreciate you've done it, and I'm so happy I see him every once in a while, and it was fun. So today's no different. Thank you for coming. So the visiting program, we bring legal scholars here. That's the point, or government officials and prominent members of the legal and business communities to the school to talk about international law and international programs. Today's going to be no exception. And then we have the visitors teach one of Julian's classes, if any of you were there today, as he did, and talk about various issues, about international law and trade. So it's a great program that we've greatly rewarded. We've had a number of wonderful speakers. Honorable Sang-Hyun Song, who's the President Judge of the International Criminal Court. Thomas Graham, who was on the World Trade Organization appellate body. Miguel de Soares, who is something, I turn the page, Undersecretary General for Legal Affairs and United Nations Legal Counsel, and just a number of wonderful speakers, and today's will be no different. So thank you again, Phil, for doing all this for us. And my job now is to introduce Julian Coup, who is the Maurice A. Dean Distinguished Professor of Constitutional Law and Faculty Director of our International Programs. And it's interesting that his professor in the school's name is the same. I don't know, there must be some portent from that, and I'm not sure what it is. And thank you for all continuously organizing these programs you do, and all of your work on international law. The students that you do has been great. And thank you for bringing our wonderful speaker, Paul Reichler, who is joining us today. And Professor Mr. Reichler, as you hear, has quite an extraordinary career. So, Julian, take it away.
Great. So thank you, Dean Lane. Thanks. I also wanted to add my thanks to Phil Shapiro for allowing all this to happen, really making it possible for us to bring really distinguished and fascinating figures from the world of international law and practice to Hofstra for our students to get a chance to hear from them, and of course our faculty as well. So let me just not take up too much more of your time, quickly do a brief introduction for our speaker today. Paul Reichler, Chair of international litigation and arbitration at the Washington, D.C. law firm of Foley and Hogue. Now, that's a very impressive title, but in fact, very few chairs of international litigation and arbitration at any large law firm in the world could really boast the kind of practice that Mr. Reichler has had in his career. Literally, his primary, almost exclusive focus is on litigation between sovereign states, or disputes between sovereign states or involving sovereign states. In other words, legal problems of governments, foreign governments for the most part. This is literally, when we talk about international law litigation, this is in its most classical form, where countries dispute with other countries and take their disputes somehow to a court, or an arbitration tribunal, or a domestic court, or some fora where law, as opposed to pure diplomatic or political relationships, will be an important role in resolving, hopefully, or managing the dispute states and governments have with each other. His roster of cases and disputes is too long, really, for me to go through, but there's a few I just pick out, which I think I'll just want to highlight before I introduce him. So he got his start, as many of you know, in the very famous case, which is still taught in the international law class every day, every year, Nicaragua versus United States, and he represented Nicaragua, which is a little unusual for an American. Uruguay against Argentina, in a dispute over, very complex dispute, I believe over and pollution on a river, rights to a river, of states over use of a river they share in common. It's much more important and exciting than I just made it sound. He represented Uruguay. Georgia against Russia. Guess which side he represented? Georgia. Bangladesh against India in a maritime dispute over the borders. So you recently had a visitor from Bangladesh. It actually is a very large country, but it's not nearly as large as India. And sorry, I represented Bangladesh. And then most recently, in a case that was just decided this past summer, where I've become very interested in this case, Philippines against China, and he represented, of course, the smaller country, Philippines. And this is actually an interesting theme to work. In other words, he's representing, in some ways, the harder case to present, and the harder case to achieve a result for is a small country seeking, in some cases, to use international law in some way to affect or change or improve its relationship with sometimes gigantic powers like the United States, Russia, China. And to do this through the medium of a private practice in Washington, D.C. as an American lawyer is, I think, a fascinating and remarkable story to tell. And his experiences and his observations over the years, I think, are definitely worth sharing or learning more from as students and as observers of the world in international law. So with that, let me turn it over to Ms. Reichler. Thank you again for coming.
Dean Lane, Phil Shapiro, Professor Coup, faculty, students. It's an honor for me to be invited to Hofstra to deliver the 2016 Philip J. Shapiro Endowed International Visiting Scholar Lecture, and I'm deeply grateful for your invitation. I'm especially pleased to have received the invitation to be here from Professor Julian Coup, who is one of our country's leading and most distinguished authorities in international law. The Maurice A. Dean School of Law is an outstanding law school and is very fortunate to have professors like Julian Coup on its faculty. And speaking of those who are fortunate, I include myself in that number. I've been blessed with good fortune throughout my career as an international lawyer. Most recently, between January 2013 and July of this year, I had the privilege of serving as lead counsel for the Philippines in its arbitration against China over maritime rights in the South China Sea. The award in that case, issued on July 12th, came almost exactly 30 years to the day after the judgment of the International Court of Justice in Nicaragua versus United States of America, which was my first international case. The two cases have important elements in common. In each case, a smaller, weaker state invoked international law and pursued international adjudication to assert its rights against a much more powerful state, a great power that it could not hope to confront on equal terms in any other theater, political, economic, or military. In each case, the smaller state won, in the sense of obtaining a final and legally binding judgment or award from a competent and prestigious international tribunal, vindicating its rights, condemning the unlawful conduct of the great power, and ordering it to bring its conduct into conformity with the law. Also in both cases, the great powers abandoned the proceedings, at least in part, and refused to comply with the tribunal's ruling. Both cases, therefore, raise the question, is it worth it? Can international law and international courts be used to call the great powers to account, to hold them to the same legal standards that are applied to all other states, and to make them respect the rule of law? The cases also raise the question of whether international tribunals should be used for this purpose. Does it strengthen the rule of law to bring great powers before the courts? Or does it weaken law by exposing its limitations, if not its powerlessness, to address the violations, the abuses of rights, trespasses on sovereignty, infringements on political independence and territorial integrity committed by the most powerful states? Respectable arguments can be made on both sides. As international lawyers, whether scholars or students or practitioners, it's our vocation to promote and protect and strengthen the rule of law in international affairs. We believe that law is a positive force, which facilitates peaceful and efficient political and commercial relations between states, that establishes mutually agreed or customarily observed standards of conduct that are accepted as fair, that respect the sovereignty of individual states, and that enhance the predictability of their behavior and thus promote the regularity and stability of the international order. But what if, in our enthusiasm for extending the rule of law, we stretch it to the point where it is too thin to contain the pressures of powerful states determined to pursue what they perceive as their own strategic interests? Do we do more harm than good, despite our best intentions? Well, I'll leave it to each of you to form your own conclusion, but not before relating some of my most vivid professional experiences in dealing with this important question, and sharing with you the answer that I have derived for myself. The Nicaragua case was a response to the efforts of the United States to overthrow Nicaragua's government. The United States recruited, armed, trained, financed, and directed a guerrilla army, known then as the Contras, to attack Nicaragua from bases in neighboring countries. In furtherance of this effort, the United States, through its own personnel, mined Nicaragua's harbors and carried out sabotage operations against oil storage facilities and other strategic targets inside Nicaragua. U.S. conduct was a flagrant violation of customary international law, reflected in Article 2.4 of the United Nations Charter, among many other sources, which prohibits the use of force against the territorial integrity, political independence, or sovereignty of another state. Nicaragua's diplomatic efforts to resolve its differences with the United States were spurned by Washington. Exactly 15 years ago, on what was then the 15th anniversary of the ICJ's judgment in favor of Nicaragua, I published in the Harvard International Law Journal a behind-the-scenes account of how Nicaragua, a revolutionary government, came to consider and then bring a lawsuit against the United States in the World Court. For those interested in the whole story, I refer you to that article. But for present purposes, and due to time constraints, I'll simply say that Nicaragua concluded it had no other viable option. It tried diplomacy, both unilateral and multilateral, without effect. The war imposed on it by the United States, coupled with an economic embargo, devastated its already fragile economy and brought it under seemingly insurmountable military pressure from the world's most powerful state. No developing state had previously attempted to sue a great power, let alone over the use of armed force, or a matter that the great power, however unreasonably, considered important to its national security interests. I've heard scholars, including my friend Professor Coup, cleverly refer to such an initiative as waging lawfare. I have some difficulty with the word because it sounds too much like warfare, and seeking the peaceful settlement of a dispute according to international law may be as far as you can get from waging war. But semantics aside, if this is what Nicaragua did, it invented the concept. Nicaragua was able to sue the United States because both had accepted the ICJ's jurisdiction under the optional clause of Article 36(2) of the court statute. Both had submitted declarations pursuant to that provision, accepting the court's jurisdiction vis-a-vis any other state that had also given its acceptance. This is a crucial factor in using international courts and tribunals to obtain international justice. Jurisdiction over sovereign states is not universal. It's subject to their consent. Accepting ICJ jurisdiction under the optional clause is one means by which such consent is given by a state. It's also commonly given in dispute settlement clauses in bilateral or multilateral treaties. But in those circumstances, jurisdiction is limited to disputes with other treaty parties and to the subject matter of the treaty. I'll give you some examples in the course of these remarks. The United States appeared in the case to defend against Nicaragua's request for interim measures of protection, which the court imposed in virtual unanimity, and to challenge the court's jurisdiction, which the court overwhelmingly upheld. Thereafter, the U.S. withdrew from the proceedings, but nevertheless submitted arguments and evidence on the merits of the case informally, which the court received and considered. The U.S. did not deny its conduct, but attempted to justify it as collective self-defense. In particular, the U.S. argued that it waged war on Nicaragua in defense of El Salvador, which, according to the U.S., was being attacked by Nicaragua via alleged arms shipments to rebels fighting El Salvador's government. The court found that there was no merit to the United States' arguments. First, there was no evidence that Nicaragua had sent arms to the Salvadoran rebels. In fact, the CIA analyst responsible for monitoring Nicaragua's relationship with the rebels testified before the court that Nicaragua had not supplied arms to the rebels and that there was no evidence of that. Second, the court ruled as a matter of law that the U.S. did not meet the requirements for invoking self-defense because, among other things, it used military force unilaterally in non-exigent circumstances without prior consultation with the Security Council. The U.S. was thus ordered to cease all of its support for military activities in and against Nicaragua. The U.S. administration, under then-President Reagan, was furious with the court and vowed not to comply with the judgment. But that wasn't the end of the story. The judgment of the ICJ had a major impact on U.S. public opinion and the attitudes of members of the U.S. Congress. The central issue in the debate was no longer whether Nicaragua posed a threat to the security of the United States, but it had become whether U.S. interests were served by engaging in aggression against a small state in violation of fundamental principles of international law, of which the U.S. itself had historically been a champion. This turned out to be enough to turn the tide in Congress, and persuade a majority to cut off all further funding for armed activities against Nicaragua. The cutoff of U.S. support led the Nicaraguan government and the Contras to enter peace negotiations to end the war. Despite U.S. opposition, an agreement was signed as a direct result of the ICJ's judgment. The Contras then disarmed, and democratic elections were held 2 years later. They've been held regularly ever since. Political power has alternated, and without interference from the United States, Nicaragua has enjoyed civil peace. The judgment also had important effects on the court itself. Prior to the Nicaragua case, the ICJ was viewed with suspicion by developing states, which saw it as an institution dominated by the West, particularly the United States and European colonial and former colonial powers. Left-leaning governments especially regarded the court as an untrustworthy arm of a capitalist and imperialist international order. The Nicaragua judgment profoundly changed that perception of the court. I've talked with every registrar of the court since 1986 and with many of the court's judges since then, and they all agree. They point in particular to the great expansion of the court's docket following the Nicaragua case, especially on the part of developing states from Latin America, Africa, and Asia. The Nicaragua case gave the court credibility as an impartial arbiter of interstate disputes, where smaller states could meet their larger rivals on an equal footing in the eyes of many states that had previously been skeptical and reluctant to resort to it. Most of you will agree, I'm sure, that it's a good thing for more interstate disputes to be submitted to the court. This ensures, above all, a peaceful settlement, rather than resort to other means, or allowing disputes to fester and aggravate tensions. And it strengthens the rule of law not only by its application to resolution of a particular case, but also by encouraging other states to follow suit and seek to resolve their disputes peacefully in accordance with law. Not every recourse to the court against a great power has been as successful as Nicaragua's case. In August 2008, Russia invaded Georgia in support of uprisings in two breakaway Georgian provinces, South Ossetia and Abkhazia. In fact, there was an article in yesterday's New York Times about this conflict for those of you more interested in it. These were ethnically mixed areas of Georgia. The Russian forces collaborated with Ossetian and Abkhaz militias to take over the provinces and drive out all ethnic Georgians. The Georgians were rounded up, beaten up, and made to watch as their homes and entire villages were razed to the ground. There was no possibility of a military defense. The Georgian army was no match, of course, for Russia's overwhelming force. And diplomatic negotiations were frustrated by Russia's determination to topple the government of Georgian President Mikhail Saakashvili. Or in the words of President Vladimir Putin, he wanted to see President Saakashvili, quote, hanging by his balls. To which President Saakashvili replied, via the good offices of the President of France, quote, Putin doesn't have a big enough rope. I think today we might refer to this as locker room talk. But it was no laughing matter for Georgia or the tens of thousands of Georgian villages who were driven from their burning homes at gunpoint and forced to live in squalid refugee camps in Georgia proper. Georgia responded by reaching out to the international community for support and by suing Russia in the ICJ. Because Russia had not accepted the court's jurisdiction under the optional clause, a relevant treaty providing for ICJ jurisdiction to which Russia was a party had to be found. There was no such treaty prohibiting armed aggression or military invasion. The best one Georgia could invoke was the United Nations Convention for the Elimination of All Forms of Racial Discrimination. It prohibited, among other actions, discrimination based on ethnicity, including ethnic cleansing, which is what occurred in South Ossetia and Abkhazia after Russia invaded. Georgia's first efforts were successful. It persuaded a thin majority of the court to order interim measures of protection, prohibiting Russian forces and the local militias under their command from continuing their discriminatory practices against ethnic Georgians in their villages. But the thinness of the majority was not a good omen. A significant number of judges had doubts of whether Georgia had made the requisite prima facie showing of jurisdiction to warrant interim measures. Russia, to its credit, appeared at the oral hearings to contest the imposition of these measures. It subsequently filed preliminary objections to the court's jurisdiction. These were elaborately argued and based primarily on the alleged failure of Georgia to satisfy the preconditions to seizing the court of jurisdiction under Article 22 of the Convention, which was the Dispute Resolution Clause. Russia argued that Georgia had sought negotiations to stop it from, one of those conditions under Article 22 was that negotiations to settle the dispute be attempted before either party could take the dispute to court. Russia argued that Georgia had sought negotiations to stop it from sending troops into Georgian territory, but had never attempted to negotiate over the specific violations of the convention alleged in its lawsuit, that is, the ethnic discrimination practiced by Russia and its local allies after the Russians invaded. At the oral hearings on jurisdiction, Georgia invoked the futility of attempting such negotiations at a time when Russian tanks were within 40 kilometers of its capital and rushing full speed ahead, and the Russian president had said, in colorful language, that nothing short of the removal of his Georgian counterpart would stop the advance. But the court, by a 10-6 majority, upheld Russia's jurisdictional objections and terminated the proceedings. It explained that under Article 22 of the Convention, jurisdiction would lie only if there had been unsuccessful negotiations over the specific subjects covered by the Convention. Military invasion and aggression were not covered. Georgia attempted to regroup a short while later by calling upon Russia to enter negotiations specifically over ethnic discrimination in an effort to check the jurisdictional box created by the court and return to The Hague. However, while these diplomatic efforts were underway, national elections were held, and the Georgian opposition, backed by generous Russian financing, won office, and Georgia's legal efforts sadly ended there. This case shows some of the challenges facing states that wish to take their disputes from other states, especially great powers, to international courts or tribunals. First, an agreement or treaty conferring jurisdiction must be found. Second, the agreement or treaty must cover the subject matter of the alleged violations of international law. And third, the specific preconditions set forth in the treaty for the exercise of the court's jurisdiction must be strictly complied with. Now, to these challenges, some observers might suggest fourth, overcoming the aversion of at least some judges or arbitrators to exercise their jurisdiction over a great power. Why might there be such reluctance? Some jurists could feel that any judgment they might be inclined to enter against a great power, especially in a case involving military activity, is likely to be ignored, undermining respect for the court. They might also be concerned that such a judgment could provoke the great power to withdraw from treaties conferring jurisdiction on the court. Now, there's no evidence that any judges of the ICJ took these institutional as opposed to case-specific factors into account in upholding Russia's jurisdictional objections to Georgia's suit. But an argument can be made that it would not have been illegitimate for them to do so. maintaining respect for the court as an institution can be considered an important part of promoting and protecting the rule of law. The contrary argument would be that if a court or arbitral tribunal is going to grant exception to the rule of law for great powers, then there's no justification for maintaining even the pretense of equal justice. Several states have now attempted to have international courts or arbitral tribunals exercise jurisdiction over great powers in matters of territorial sovereignty or land and maritime boundaries, which of course are matters of great strategic and national importance to these countries. An encouraging example is the arbitration brought by Bangladesh against India under the United Nations Convention for the Law of the Sea. For present purposes, I will regard India as a great power. If it is not already one, it's certainly on the way to becoming one, and in any event, in relation to Bangladesh, it clearly qualifies. At stake in that case were more than 100,000 square kilometers of sea and seabed in the Bay of Bengal, in areas thought to be rich in oil and gas. Neither the land boundary terminus nor the maritime boundary had ever been agreed. At one point, naval gunships from both states faced each other across a disputed low tide elevation near shore and came very close to starting a war. In more recent years, India had taken advantage of its superior power to license oil and gas exploration in the disputed area and use its Navy and Air Force to keep Bangladesh out. Bangladesh invoked Part 15 of the Law of the Sea Convention and instituted compulsory arbitration proceedings against India to delimit the boundary. That set of provisions obligates all parties to the convention to submit the compulsory dispute settlement in regard to disputes arising under the convention, with few exceptions. India demonstrated its commitment to the fulfillment of its treaty obligations and the rule of law by appearing in the arbitration, participating in the selection of the tribunal, and arguing its case on the merits in voluminous written pleadings and at the oral hearings. But India went even further to demonstrate its commitment to the rule of law when it accepted and fully complied with the tribunal's final award, which was widely interpreted as far more favorable to Bangladesh. In fact, the arbitrator appointed by India dissented, the lone dissenting vote, on the ground that the award was much too favorable to Bangladesh. This might have made it more difficult politically for India to comply. Nevertheless, it did. The Law of the Sea Convention, which was carefully negotiated by UN member states over more than a decade, and now has more than 180 states parties, is distinguished by its provision for compulsory settlement of all disputes regarding interpretation or application of the convention. States are permitted to opt out of compulsory settlement of only a few specific types of disputes. Where the parties to the dispute have not agreed on the form, the convention provides for compulsory arbitration in accordance with the procedures set forth in one of its annexes, Annex 7. These are the provisions of the convention that the tiny island nation of Mauritius invoked in initiating arbitration against the United Kingdom. Part 15 and Annex 7 of the convention. Mauritius claimed that it had sovereignty over the Chagos archipelago, which includes Diego Garcia Island, where the United States has maintained an important military base since the 1960s. Mauritius also claimed that it had sovereign rights to the living and non-living resources in the sea surrounding the archipelago, and that the UK's unilateral declaration of a no-fishing zone in these waters, which denied Mauritius access to the fish and other resources, violated Mauritius's rights. The origin of Mauritius's claims was the unlawful manner in which the United Kingdom granted Mauritius independence. It had been a British colony since the end of the Napoleonic Wars. The Chagos archipelago was administered as an integral part of the colony of Mauritius. However, in violation of its legal obligations in respect of decolonization, which required that colonial possessions be granted independence in their entirety, the UK severed the archipelago from Mauritius and kept it for itself, so that it could then lease Diego Garcia to the US for military purposes. Mauritius was compelled to accept this arrangement as a condition of its independence, but never stopped protesting, claiming its sovereignty over the archipelago or seeking its return. Mauritius initially planned to sue the UK in the International Court of Justice, based on the UK's acceptance of the court's jurisdiction under the optional clause. When the UK got wind of these plans, it amended its optional clause declaration to exclude cases brought against it by members of the Commonwealth. When Mauritius withdrew from the Commonwealth, the UK again amended its declaration, this time to exclude cases brought by former Commonwealth members. And this, of course, is another illustration of the jurisdictional challenges that face small states seeking to hold great powers, or in the UK's case, former great powers, making them accountable. Mauritius settled on arbitration under the Law of the Sea Convention because jurisdiction over the UK was possible. However, Mauritius's difficulty was, as I mentioned earlier, that the jurisdiction of law of the sea tribunals covers only disputes that arise under the convention. And the convention does not cover matters of sovereignty over land territory, including islands. Mauritius therefore had to develop creative arguments to bring its claim of sovereignty over the Chagos archipelago within the provisions of the convention. Essentially, it argued that decolonization is so fundamental to the UN Charter that these rules and the General Assembly's resolutions interpreting them, violated by the UK, are jus cogens, peremptory norms of international law, for which reason the UK could not lawfully be regarded as sovereign with regard to the Chagos Islands. 2 of the 5 arbitrators, who were highly regarded judges on the International Tribunal for the Law of the Sea, agreed with Mauritius. But by a 3-2 majority, the tribunal declined to exercise jurisdiction over Mauritius's sovereignty claims. Mauritius fared a lot better with its claims for violation of its rights to the resources of the waters and seabed surrounding the Chagos archipelago. The tribunal ruled unanimously in Mauritius's favor on those claims and declared the UK's unilateral declaration of a no-fishing zone unlawful. This was a very important accomplishment for Mauritius, even if it did not redress Mauritius's sovereignty claim. The case illustrates both the extent and the limits of pursuing claims against great powers before international tribunals, especially under the Law of the Sea Convention. If you've been waiting for me to discuss the Philippines-China case, now is the time. So, happy to satisfy you here. Like Bangladesh and Mauritius before it, the Philippines invoked Part 15 and Annex 7 of the Law of the Sea Convention to obtain compulsory jurisdiction over China and initiate legally binding international arbitration proceedings. This is the situation the Philippines faced in June 2012 when I was first asked by the government to provide legal advice on options that might be available to it. First, China was insisting on its exclusive jurisdiction over nearly all the waters and all the seabed of the South China Sea, within a so-called 9-dash line, and the exclusive right to all of the natural resources within that line. You see behind me on the slide the official version of the 9-dash line and China's claims in the South China Sea, which China made public for the first time in 2009. Can I operate? Here it is. Okay. Did I do that, or did somebody else? This is another view of the 9-dash line. And here, the red line at the top represents the 200-mile limit of China's jurisdiction for their exclusive economic zone and continental shelf under the Law of the Sea Convention. The entire pink area is what China is claiming and still claims beyond its legal entitlements under international law. And as reflected here, China's claim extends more than 650 miles from its mainland coast and within 50 miles of the Philippines coast. You can see the Philippines on the eastern side of the South China Sea, the main island of Luzon in the north, and then in the southwest of the Philippines, but southeast of South China Sea, that snake-like figure is Palawan, another major island of the Philippines. So China was claiming areas of sea and seabed more than 650 miles from its coast and within 50 miles of the Philippines coast, and of course well within the Philippines' 200-mile exclusive economic zone and continental shelf, to which the Philippines alone would be entitled under the Law of the Sea Convention. Now, second, Chinese, again, talking about the situation in June of 2012, Chinese naval and law enforcement vessels were preventing Philippine fishermen from fishing within these waters and preventing Philippine licensees from exploring for oil and gas while permitting Chinese nationals to carry out these activities. Third, China forcibly excluded Filipino fishermen from Scarborough Shoal. You see the red circle in the northeast off the coast of Luzon. A series of rocks jutting above the water around the lagoon, and it's a very fertile fishing area where Filipino fishermen had exercised their livelihood for centuries. Only Chinese nationals were therefore allowed to fish in the vicinity of the shoals. Fourth, China claimed sovereignty over all of the Spratly Islands, which is a cluster of small features in the south, which consisted of dozens of tiny uninhabitable features simultaneously claimed by the Philippines, Vietnam, and Malaysia, as well as China. China occupied and built or started to build military facilities on top of 7 of these features. One of them, Mr. Reef, was a low tide elevation, only 100 miles off the Philippines coast and well within its exclusive economic zone on the continental shelf. This encroachment on the Philippines was particularly threatening, especially as it created the fear that China would continue its advance and occupy other similar features even closer to the Philippines coast. The Philippines had tried diplomacy with China, but China was intransigent. It demanded that the Philippines accept Chinese sovereignty over all of the islands and other maritime features in the South China Sea, and acknowledge exclusive Chinese rights over all of the resources within the 9-dash line. This would have amounted to a complete renunciation of the Philippines' rights under the Law of the Sea Convention. Only by the Philippines' prior acceptance of these conditions, China insisted, would it then consider whether and to what extent Filipino fishermen could fish in the South China Sea. Negotiations took place at various intervals over a 15-year period, always following the same script. No progress toward an agreement was or could be made, and obviously a military solution for the Philippines was even less likely than a diplomatic one. The challenge facing the Philippines and its lawyers was how to frame a case under the Law of the Sea Convention that would, 1, survive anticipated jurisdictional objections by China, yet 2, enable the Philippines to obtain meaningful relief. On the first, there were 2 obstacles to jurisdiction looming over the case. The first one, as was confirmed by the arbitral tribunal in the Mauritius UK case, the tribunal established under the Law of the Sea Convention has no jurisdiction over questions of land sovereignty. And for that reason, the Philippines could not challenge China's assertion of sovereignty over the Spratly Islands or Scarborough Shoal, which represented and still represents one of the main sources of conflict in the South China Sea. And second, the Philippines could not ask an arbitral tribunal to delimit a maritime boundary with China because China had exercised its right under Article 298 of the Convention to exclude itself from compulsory arbitral jurisdiction in regard specifically to boundary delimitation. The solution, after much thought, analysis, and debate, was to bring a case based on maritime entitlements, rather than about sovereignty over islands or delimitation of boundaries. Maritime entitlements, that is, the entitlements to the sea and seabed generated by mainland coasts and islands, including a 12-mile territorial sea and 200-mile exclusive economic zone in the continental shelf, are specifically provided for in the Convention, and thus, unlike sovereignty over land, fall within the jurisdiction of a tribunal established pursuant to Part 15. Also, entitlements are determined without the need for engaging in the delimitation of boundaries. In fact, tribunals must determine the entitlements of the parties to a dispute prior to delimiting a boundary, because it is only when their entitlements overlap that a boundary needs to be created. So I'm going to give you a very minimal course in law of the sea. Here it's State A and State B, separated by 500 miles. They're opposite one another across a body of water. As you can see, each one has an exclusive economic zone and continental shelf extending 200 miles. But where they're more than 400 miles apart, there's no overlap of their entitlements. So each one has the exclusive enjoyment of its 200-mile entitlement, and the area in between is the high seas. Now, we can contrast this with the situation on the X, where the states, State A and State B are still opposite one another, but now the body of water separates them by only 300 miles as opposed to 500 miles. In this case, each one still has a 200-mile entitlement, exclusive economic zone and continental shelf. But as you can see, there is an area of 100 miles, width of 100 miles, where they have overlapping entitlements. Now, where states have overlapping entitlements, that is where boundary delimitation is required in order to determine where the rights of one state and the other begins. So, this is the basic premise on which our case against China is built. We were confident that by focusing exclusively on entitlements rather than sovereignty or delimitation, we could survive China's jurisdictional challenges, and this proved correct. Although China did not formally appear in the arbitral tribunal, in the arbitral proceedings, it submitted to the tribunal a very well-written pleading setting forth its jurisdictional objections. Its main arguments were that the tribunal lacked jurisdiction over matters of land sovereignty and boundary delimitation. The tribunal had no difficulty in rejecting these arguments unanimously because, as it emphasized, the Philippines had taken pains not to raise issues of land sovereignty or boundary delimitation, but had presented its case entirely as one regarding maritime entitlements. That left the question of whether a case about maritime entitlements, which survived jurisdictional objections, would be enough for the Philippines to justify its recourse to arbitration. Now I'll show you why it was. What you see here, again, are remember the red line represents China's 200-mile entitlement limits under the North Sea Convention. The blue line represents the Philippines' 200-mile entitlements. Now, this slide shows, as I said, the 200-mile maritime entitlements generated by China's and the Philippines' mainland coast. For the purposes of this exercise, although the Philippines is a group of islands, I'm referring to their larger islands and their coast as mainland coast. As you can see here, there is very little area where they overlap, except for the small area off the Philippines' northwest coast. None of the Philippines' entitlements are overlapped by any of China's. The Philippines thus enjoys exclusive entitlements in these areas, including to all the resources of the sea and seabed. Now, this is like the first situation that I I showed you, that the two states separated by more than 400 miles. Now, this is the case except for China's claim based on its 9-dash line, which is not on this map, but you can envision it just following the outline of the South China Sea coast. So for this reason, the most important objective of the case from the Philippines' perspective was to establish the unlawfulness of the 9-dash line claim. The Philippines argued that as a party to the convention, China enjoyed all of the entitlements set forth therein, but that these did not extend beyond 200 miles. Therefore, any Chinese claim beyond 200 miles, especially one that extended within 200 miles of the Philippines, was a violation of the convention. This seemed to us an obvious point, and the tribunal agreed unanimously. Now, I should advise you that I probably have another 15 or 20 more minutes if I'm allowed, so if anybody has to leave, feel free to do that. I don't take offense.
Yeah, then we need to get out there.
I'll do it in 10. Now, China's maritime claims extended not only from its mainland coast, they also extended from Scarborough Shoal and the Spratly Islands, over which China claimed sovereignty, as I said. So an important issue in this case, and the second most important issue in the case, was whether these features, and you can see them circled, were capable of generating maritime entitlements, and if so, to what extent. The matter turned on the meaning of Article 121 of the Convention. That article provides that islands generate the same maritime entitlements as mainland coasts, including a 200-mile exclusive economic zone on the continental shelf. However, there is an exception for islands that are considered uninhabitable, specifically features that are incapable of sustaining human habitation or economic life of their own. Those islands, generally very small and barren ones in their natural state, have an entitlement only to a 12-mile territorial sea. Accordingly, the Philippines argued and presented voluminous cartographic, historical, anthropological, and scientific evidence that neither Scarborough Shoal nor any of the Spratly Islands was habitable, such that none of these features generated entitlements beyond 12 miles. Significantly, this was the first case in which any international court or tribunal was called upon to interpret the relevant provision of Article 21, or determine whether and on what basis an island should be deemed uninhabitable as a matter of law. The tribunal, which was composed of 5 of the most eminent and well-respected jurists and scholars in international law, delivered, as part of its award, an extensive analysis of the meaning of the text and the manner in which it is to be applied. It came to the conclusion, again unanimous, that none of the islands in question was habitable in its natural state, and that none of them, therefore, generated entitlements beyond 12 miles. On this basis, the tribunal ruled that it was unlawful for China to deprive the Philippines of the exclusive enjoyment of the areas of sea and seabed, including the living and non-living resources within 200 miles of the Philippines coast. And there were other important issues in the case, but I'm going to pass over them in the interest of time. Let me now try to give you the best answers I can to the question of whether these cases are worth the effort. Specifically, is the rule of law best served by subjecting the great powers through judicial and arbitral processes to the same legal standards as everyone else, even in regard to matters that they regard as important to their national interests, or by seeking to extend the application of legal rules beyond what may be their practical limits, do we unwittingly undermine them and the rule of law generally? Begin by saying I don't believe in American exceptionalism. at least if that term is defined to mean that the United States is free to abide by or ignore international law as it sees fit in the exercise of its own national interests. Nor do I believe in Russian exceptionalism, or Chinese exceptionalism, or anyone else's exception or exemption from the rule of law. The United Nations Charter gives a special role to certain of the world's most powerful states. It makes them permanent members of the Security Council, and it gives them veto power over Council resolution. But it does not exempt them from the rules set forth in the Charter or any other rules of international law. Nor do United Nations conventions, such as the Law of the Sea Convention, or the Torture Convention, or the Geneva Conventions, or other multilateral treaties, make exceptions to their rules for the great powers. The same fundamental legal principles reflected in international agreements or adopted by customs apply to all states. It could not be otherwise. The majority of states simply would not accept being bound by rules that exempted other states solely on the basis of their power. Otherwise, right would be made subordinate to might by express agreement of the majority. Who would accept such a system except the Most High and Mighty? Without acceptance by the vast majority of states, there is simply no rules-based international order, none. But it may be one thing to conclude that the great powers are bound by the same legal rules as other states, and another to conclude that they should be held accountable before international courts and tribunals, and compelled to comply with their judgments and awards, interpreting and applying those rules. Is that pushing the rule of law too far? Again, I think not. First, I don't think the majority of states would accept a system in which they are required to comply with the binding orders of competent international tribunals, but other states, even great powers, are not. The great powers do lead by example, and this can be either good or bad. If they refuse to honor their legal obligations, so will other states, and soon enough, international adjudication will be a hollow exercise. In 2012, when Colombia defiantly told the ICJ it would not comply with the court's judgment delimiting its maritime boundary with Nicaragua, it cited the United States' rejection of the 1986 judgment in the earlier Nicaragua case. China, too, cited the U.S. reaction in the Nicaragua case in support of its rejection of the arbitral award in the Philippines case. But fortunately, these acts of defiance of international courts and tribunals are, at least so far, rare exceptions. The vast majority of states, in the vast majority of cases, comply with judicial judgments and arbitral awards, even in cases where they consider themselves to have lost. India, in the Bangladesh case, is far from alone in that regard. The United States, despite the Nicaragua case, has a decent record of compliance with international judgments and awards. So too, and this may surprise you, does China, at least in the context of World Trade Organization panel rulings. China has been complying even with those rulings that go against it. And there are reasons why states on the whole have such a good record of compliance, even with unfavorable judicial or arbitral outcomes. First, there is an advantage of finally resolving a dispute with another state. Even if the resolution is less than desirable, the alternative, prolongation of the conflict, tension and instability in the bilateral relationship, and the imminent or eventual possibility of armed conflict is often worse. Second, neighboring states never move out of the neighborhood. Geographic proximity among states is permanent. Disputes between neighbors are inevitable. If state A doesn't comply with the court's judgment resolving today's dispute, how can it expect its neighbor, state B, to comply with one in the next case? By refusing to comply, state A will have removed judicial or arbitral recourse from the list of possible means of resolving a future dispute that cannot be settled diplomatically. And what alternatives does that leave? Third, there is the value of stature, prestige, and reputation, which translates into influence on the international level. States enhance their stature, and with it their influence, when they demonstrate that they are law-abiding, including by complying with international judgments and awards. President Obama made this point recently. But states demonstrate this repeatedly. Inevitably, they seek to justify their actions on the basis that they are consistent with international law. We see this in all kinds of situations, even where the reliance on international law seems misplaced. China itself has argued that its 9-dash line claim is based on international law, namely its alleged historic rights to far removed waters and seabed, in addition to the rights it claims under the Law of the Sea Convention. The arbitral tribunal dispensed with this argument, as it should have. But my point is not that states correctly invoke international law to justify their policies and actions, simply that they do so. And that is because they consider it important to their own self-interest to be seen by their neighbors and the international community as a whole as law-abiding and respectful of the rights of other states. Why do they care? Because it enhances their stature and thus their influence and thus their power. Fourth and finally, I believe that states understand that the alternative to a rules-based international order is chaos. Respect for the rule of law serves not only ethical and moral interests, including justice and fairness, but practical ones. It fosters predictability, stability, security, and peace in international relations. These are goals shared by most states most of the time. In fact, great powers may have the greatest interest in preserving the existing international order and their privileged levels of influence under it. Maintaining and strengthening that order requires them to accept the consequences on those occasions when its rules are applied against them. No rules-based system whose legitimacy is widely accepted can allow a particular state, no matter how powerful, to win automatically every time. No great power can reasonably have such an expectation. There will be times, therefore, when such a state's behavior is found to be unlawful. That may present as much of an opportunity for strengthening the legal order as a challenge to it. There might be no better way to promote the rule of law than for a great power, like the United States or China, to accept and comply with an occasional adverse judicial judgment or arbitral award. They do so, at least from time to time, because they understand that there is no possibility of a rules-based system that will allow them to win every time, no matter what they do. And there is no viable alternative to such a system that will protect, over the long term, their interests in a more orderly and secure world. So, in the end, we are left with an imperfect international legal order, but one that is far better than having no rules-based system at all. The great powers may be powerful enough to get away with defying court orders and arbitral awards from time to time, but this is not sufficient reason to legitimate such behavior by granting them exceptions from the rules or adopting a policy of not seeking to hold them accountable for their unlawful acts. To the contrary, we are better off with a legal system that occasionally proves too weak to contain the lawless excesses of the most powerful states than with an even weaker system that, in formal recognition of its weakness, tolerates such excesses and avoids treating them as unlawful, or worse yet, with no system at all. In my opinion, the response of international lawyers and scholars to the imperfection of the international legal order should be to continue working to make the system better and stronger, and the rules more universally enforceable. There is, to be sure, a long way to go. But we and our predecessors have made great progress, and there is no reason to give up the effort to make all states, including the most powerful, accept legal accountability for breaches of the applicable rules.
Okay, well, thank you so much. I kind of did not manage time. This is really my fault, not the speaker's fault. I did want to give anyone who has stayed to ask, we can answer one or two questions, I think, you want to raise while we I can't see someone. Oh, yes.
How do you decide which cases to take and which to reject?
How do I decide which cases to take? Well, in some cases, it's you have to wait for the client to come and seek legal advice. So often cases will come to my attention because either an existing client has a new case or a new client that I have not represented before will contact me and ask me if I and my firm are interested in taking the case. Other times, we will be aware of disputes that interest us because we feel there's value in pursuing the case, and where we have contacts with the decision makers in those countries, we might contact them and indicate our interest in helping. That's the partial answer to the question. We don't consider ourselves obligated to accept every case that's offered to us. We like to believe that we have devoted, when I say we, I mean my colleagues and I, law firm, particularly in our International Litigation Arbitration Department, we like to believe that we have what we call a values-oriented practice, and that we try to be discriminating in the cases that we take or pursue, so that we feel that we're working, if we do take the case, we're working for a just cause or a just solution, or to promote a peaceful resolution of the dispute where the alternative could be something much worse. So we do turn down clients from time to time that come to us with cases that we don't want to defend. For example, states that egregiously abuse human rights. We have been approached in certain circumstances by states asking us to defend in those circumstances, and we refused.
Okay, any other? Yes. Let me go with them, and then this is the last two. This one of those. Go ahead.
In regards to the use of the investor-state dispute settlement in international trade agreements, is there an apparent first step in shifting the commercially oriented, more corporate-focused orientation of the ISDS to a more state perspective in order for a state to maintain its sovereignty against a private entity?
Well, that's a terrific question, and it reflects a great deal of sophistication. I compliment you on that. I don't know how much time I have, but I'm going to give you a little bit of a political speech here. I think that the current system is very bad. Frankly, I have called it corrupt publicly. Corrupt not in the sense that investors or states pay the arbitrators directly to produce a certain result. It's corrupt because it's biased. The system as it exists, with 3 arbitrators, usually with the president of the tribunal casting the deciding vote, because each of the parties, the state and investor, are more likely to appoint somebody who they think is sympathetic to their side of the issue. And then it's the appointing authority, often ICSID or the International Chamber of Commerce or the Secretary General of the Criminal Court of Arbitration, who will appoint the president. And it's really, you know who won the case. I mean, we do this. I do this. I just represented Uruguay against Philip Morris in one of these cases. Unfortunately, that came out the right way. But the challenge in these cases is that they're often decided, even before you get to the hearing. They're decided when the president is appointed. And you can pretty much guarantee how the case is going to come out at that point. And appointing authorities, if you think about this, who is their constituency? Whether it's ICSID, ICC, or the Secretary General of the PCA. Their constituency is the community of investors. Why? Because all of these cases are brought by investors against states. States don't bring arbitrations under these investment treaties against investors, except in very rare cases. It's always investor against the state. So you have these different forms competing with one another to get the business. Because they're bureaucratic entities, they require constant nutrition in the form of new cases, new business, new clients. And so they have to be very careful in appointing presidents of tribunals so that it's somebody who is not unacceptable to the investor. Otherwise, the investor will decide to take the next case, or the next investor will take the case to a different forum, where that investor thinks they'll get a more favorable president of the tribunal. So the whole system tends to be biased in favor of investors. Then you have a fraternity of arbitrators, and I use the term fraternity literally and pejoratively because they're all men. In fact, they're all white men from North America or Europe that have a pro-investor ideological bias. And they seek to expand the meanings of customary international law concepts like fair and equitable treatment or expropriation or denial of justice in every case. Now you couple that with what I see as a very dangerous common lawization, for my term, for international arbitral awards, because arbitration is supposed to be a one-off ad hoc procedure. But now you have a group of pro-investor arbitrators deciding cases and then citing each other's decisions in the next case to develop a whole body of precedent, which we common lawyers are much more comfortable citing than civil lawyers from European countries. What you have then is pro-investor panels producing a pro-investor body of precedent. And I think a lot of states are coming to see that this is not a healthy system. And I've left out the part about how much arbitrators are paid and how they're always interested in the next appointment because they get paid a lot of money for doing this. So what I would like to see is where the European Union seems to be heading, which is creating a permanent court that is like the ICJ or the International Tribunal for the Law of the Sea, but to handle investment disputes. So that you have a sitting body of judges. You wouldn't have everyone sitting in every case, but you would have experienced, neutral, learned judges of all genders and all races who constitute this court before which investors and states would take their investment disputes. That was it.
Yeah, one last question. Thanks.
Just please remind me, how did the tribunal refer to the prior agreement between China and the Philippines, say 1947, treaty between Taiwan and Japan?
Well,
Could you repeat the question?
yeah, the question was how did the arbitral tribunal in the Philippines-China case refer to prior agreements? And particularly mentioned was a post-World War II treaty between Taiwan and Japan. Well, first of all, the agreements the tribunal did consider all relevant and pertinent international agreements, including all of the agreements that were signed in the wake of World War II, all of the peace settlement agreements. But it found that none of them covered rights in the sea, and particularly rights in the sea beyond the nearshore area of the territorial sea. There were agreements and there were disputes concerning sovereignty over the particular islands or insular features in the South China Sea, which I addressed in my remarks. And the tribunal did not decide any question of sovereignty over the land features or islands because that all parties agreed was outside of its jurisdiction. But there were no prior agreements or indeed any customs that had developed and hardened into law in regard to the maritime entitlements beyond the very narrow territorial seas of parties.
Okay, well, thank you so much, and thank you for staying for